So welcome to Ask an Expert, Avoiding Costly Litigation, presented by our fellow friends here at Pace Law. This Ask an Expert series is brought to you by the County of Simcoe, the small business centres of Barrie, Simcoe County, Orillia and South Georgian Bay, the Community Futures Development Corporations of Orillia, Nottawasaga, North Simcoe and South Georgian Bay. And I'd also like to thank the town of Collingwood for hosting this Zoom webinar and working diligently in the background. Today's session will be moderated by Irene Taylor of Pace Law, and our panelists, Don Jack, Pavle Mazik, and Andrew Camman are all experts in their respective fields and are here to answer your most pressing questions. And with that, without further ado, I'd like to both welcome and hand over to Irene Taylor. Irene, we'll just get you to unmute there before you launch.
Tim, thank you. And before we begin, our big thanks to Simcoe County, to Karen Clegg, Jesse McKibben, especially Tim Newton, and everyone who worked on this. Behind the scenes, it takes a lot of work to put these events together. I think that this one is particularly timely. I woke up to the CBC News this morning, and as luck would happen or misfortune, the headlines were focusing on small business owners. I saw small business owners crying. I saw stress etched in their face. These are terrible times with likely more shutdowns and restrictions to come. And during these times, people will fight for survival. And that means, unfortunately, there will be much more litigation. That's sort of our backdrop to this morning. We do have three experts with us. Don is more of a generalist than a specialist. Many years in commercial litigation, estate litigation, pretty much litigation of almost any type. Andrew Camman, labor and employment, just a master in his own right. And Pavle, who is both a general litigator, but also business solutions for small businesses, restructuring, and worst case scenarios, insolvencies, which at some point we're going to have to address. Without further ado, I'm going to jump into the questions for our panelists. The first one I would like each panelist to respond to. If you can comment on what you're seeing and experiencing with respect to litigation since last March, and what you think our audience can look forward to or not look forward to in the coming year. I'm going to ask Don to start this round, followed by Andrew and then Pavle. Don?
Okay, very briefly, I'm surprised, or somewhat surprised, that there is as little litigation as there is, because there's a world of hurt out there, and many, many businesses are in trouble. What it indicates to me is that perhaps they're doing the right thing, because you want to stay out of litigation if you possibly can. They may be negotiating arrangements with their landlords, with their creditors, with their customers who are slow in paying, and trying to resolve things without litigation. How much longer that can go on, I'm not certain, but certainly the level of litigation does not reflect the amount of damage to the economy that the pandemic has caused.
Andrew?
Yeah, I'm seeing a variety of things. I'm seeing owners of companies who have planned good human resources and are responding then to the pandemic in good human resources ways. And I'm seeing bad human resource companies responding in a bad way. So I'm getting a little bit of both. I've been doing a lot of consulting companies now have to face the fact that maybe they can't keep their staff. You have to be quick. You have to, and small business usually is quick. Small business usually can move on a dime and make these decisions, but it also has to be considered what happens when things get better, as they undoubtedly will, and you've decimated your workforce. So there's some considerations that have to take place. And what I've seen is most of the owners who think about these things, not just in pandemic terms, but in global terms, they seem to be doing better.
Thank you. Pavle?
Yeah, what I've seen in my practice is I've seen a very pleasant surprise that creditors are being unusually patient. I think because these problems are so widespread and everybody's having the same, creditors are focusing not just immediate recoveries, but trying to salvage as many of their customers as they can, which is a good thing. Whether or not that will continue into the spring is the big question mark on my mind. One of the things that the government did that has had very, I think, positive and some negative ramifications was the suspension of limitation periods for 6 months. But that means that you're going to see a rash of limitations dates hitting people in April. Any claim that would have been 2 years over the course of 6 months is going to start having its ultimate limitation instead of sort of at the start of this thing up to and including, I believe the date is April, thereabouts. And then you're going to start having to see people make really tough decisions of, do I pursue my rights or walk away? And limitation periods are often a chrysalis for starting litigation if people have been trying to avoid it.
So this may well be the calm before the storm.
It may be, but
Okay.
I thought that in September, and thankfully was proven wrong. So hopefully I'll be proven wrong again.
So we had many questions from the registrants. I would say the general theme is the theme of this webinar. How do you keep avoiding so you don't get into the horrific costs that are often associated with litigation? In your various areas of practice, if you could comment on what advice you would give to people to stay out of litigation and to avoid it as best they can. And this time, I'm going to start with Andrew, please, then move to Pavle and then Dawn.
The better experiences that I've had is where owners of the various companies I represent have spoken to me before they've made their decisions, and that we've taken kind of, it's not so emotional for me. For small business, to be honest with you, for any business, for owners, it's an emotional thing. The idea of laying off large groups of loyal employees is not appealing to any employer. Some see it as a sign of failure. Some see it as letting friends go and not supporting them. So what we do is we make some assessments. Now is a good time to get rid of people that you really should have gotten rid of before. And I'm seeing a lot of that happening. And as I said earlier, we're also trying to consider, how long are we going to be in this? What's going to be the result a year down the road? Where are we going to be? Now it looks like we're getting some more of those answers. It looks like there is a vaccine coming. There is going to be an end to this. And when that happens, what's your workforce going to look like? So the first steps that we're taking are sitting down, assessing what's our bankroll say, what can we afford to do, what can we afford not to do, and make some rational decisions. And I kind of sit at the back and assist in the thought process, add some calm to the boiling waters.
Thank you. Pavle?
Yeah, I would say listen, learn, and reflect. The most important thing is to keep the lines of communication open with whether it's a debtor or a creditor or somebody who owes you money, somebody you owe money to. So often litigation starts, if you point to an inciting event, it's a breakdown in communications where the parties just stop talking to each other, they stop listening to one another, they become entrenched in their positions. The reality is, if once that happens, you are sunk. And keeping the lines of communication can be done in a strategic manner. If you're very concerned about litigation, I echo Andrew's sentiments. Talk to a lawyer early. And what I've seen be very effective is write a communication in your own words that you're going to send to the other party to set out your position in writing, invite a call, invite a dialogue, but pass that through a lawyer so that you're not prejudicing yourself, but as a review only, so that it's still in your own words, so that if you put something on lawyer's letterhead, people see that as an overture to litigation and you've started the process and the dialogue can stop. The other aspect of keeping the lines of communication open is to start the dialogue early. If you let it lapse and let wounds fester, it's very hard to come back from that.
Thank you. And Dawn?
I would reiterate what Pavle has had to say. Keep the communication open, and keep in mind that apart from legal solutions, whether they be in litigation or in arbitration or mediation, quite apart from those, there are things which I would call business people's settlements, imaginative things which fall outside the four corners of the possible dispute. For example, I will charge you less per unit of the things that I have been selling you, but you are going to agree that as we move forward here with the vaccine coming, you are going to buy more, and that's going to be our current solution to the problem. Try to be imaginative and communicate.
All excellent ideas. And that said, if I were sitting in the audience right now, one of the concerns I would have as a non-lawyer is the exorbitant cost of you guys. Often people don't pick up the phone and call a lawyer because they have no idea how much per hour or how much per minute they're going to be paying. And yet what the three of you said is you can save a tremendous amount of money and pain perhaps just by asking some questions. So can you address how you would handle just people calling to ask for general advice? Andrew, you had a horrific look on your face, so you go first here.
Shocking. You ever hear that story about the guy who's got a leak in his roof? Every time it rains, water pours in, and his solution is that when it's raining, he can't fix it, and when it's not raining, it doesn't need to be fixed.
Yeah. That's a very good story.
Lawyers are a necessary evil, I guess. We take what I consider to be a progressive view, and I'm sure that my friends on the panel take the same view. I can't have my phone tied up all day answering questions for free because what I sell is my time.
Mm-hmm.
That said, when people call me with simple questions or text me or email me with simple questions that I can help with, I see it as part of A, the service that I provide to my existing clients, or B, provided that there's some connection, because as lawyers, we can't be tossing out legal advice on the basis of limited information. It's an ounce of prevention. That's ultimately the way you have to see a lawyer. Ounce of prevention. You don't want to have your disease get so bad that the patient cannot survive. Get the medicine in quick and prevent the big cataclysmic failure of your business. I mean, I get it. I do see that that sometimes the fear of that expense, you might be surprised at how little the cost is. I know that in my practice, I charge half my hourly rate for an initial consult. The idea being in that situation that don't be afraid. I'm going to take care of you. And just as Don was suggesting as a solution for businesses, we're in the same boat. We're also businesses going through a pandemic, and we can come up with creative solutions for paying overtime if that's what a business needs. There's no advantage to us as lawyers to put our clients out of business through legal bills. Ultimately, what we want is to help a business, help it thrive, so that they can pay legal costs in the future.
Good point. Pavle or Don, do you have anything to add to that? You're with different firms. Pavle, you're with DS Lawyers.
Yeah, I would add only this. I would say, you know, as expensive as a lawyer might seem, whatever your experience has been and however cash-strapped your business is, the earlier you engage a lawyer in any dispute, the cheaper it will ultimately be. That's initial sticker shock of a few hours of advice can save you an entire claim. I mean, it's to my mind, it is ruinous to think of lawyers as your last remedy and only call us when there's no other solution. If you think of a lawyer as a part of a possible solution, to give you guidance, to give you advice, to help you get out of a possible costly mess, you will do better. Because even if we can't help you resolve the entire dispute, we can help you streamline it. We can help you make it more efficient and guide down the road. I mean, if you call me and the only thing left to do is mount a statement of defense because somebody has already launched a claim against you, that's going to cost you thousands of dollars, and you have no choice but to suck it up and pay me or someone like me. Whereas if you call me for a little bit of advice, that statement of claim may never issue.
And Pavle, isn't it true that particularly in insolvency where companies are in trouble, they tend to wait too late?
Yeah, if you're calling me after you've missed payroll, there's a lot less I can do for you than if you say, I've got 6 months of cash flow and then I hit a crisis. Yeah. Planning is absolutely key, and professional advice, maybe not a lawyer, maybe an accountant, depending on your circumstances, maybe a trustee, is absolutely key. It might not, a lawyer is not a solution for every problem, but professional advice that is outside of the scope of your business is almost certainly part of any solution to a business crisis.
Okay, thank you. And Don?
Yeah, once again, I agree with what the other panelists have said, and I won't repeat it. So let's assume that the business person has kept the communications open with the opposite party. It would also assist that business person immensely, in my experience, to know what the alternatives are if the discussions are fruitless and a dispute has to be dealt with. Mm-hmm. So get that advice early, and as Andrew pointed out, most lawyers will give that initial advice at a reduced hourly rate in the hope that the client doesn't have to go there, but get the advice. Forewarned is forearmed.
Okay, thank you very much. I'm going to move now into specific areas and questions from our audience. And on that note, as you're listening in the audience, if you have further questions, please don't hesitate to send them through. And Tim has graciously agreed to pick them up. And I'll pause after my questions and we'll go to Tim to take any of the further questions that you have. So Andrew, there were a number of questions. I think a lot of the pain that's occurring right now is in the workplace. The first question is that often it's the employees who initiate the action, but they often don't realize themselves what the costs and consequences of trying to sue their employer are. What can the employer do to resolve issues early on with people who initiate action or are about to?
Yeah, I can say that we've probably terminated in the hundreds since the pandemic has begun. And as I'm sitting here right now, I can't think of any case that has gone forward to litigation. They've all been either resolved or are in the process of being resolved through negotiation. And that's not a unique experience to the pandemic. That's the way litigation, the statistics I know from litigation are that 95% of all cases get resolved through settlement before trial. Only 5% of cases actually proceed to trial. And so the emphasis has to be on getting cases resolved earlier. That's the trick. And the way you do that is I have a philosophy in terms of negotiation, and that is that hardball negotiators beget hardball negotiations. And what I like to do is I like to tell my clients what's fair, what's reasonable, and reasonable in employment terms is a range. It's never a specific answer, unfortunately, I guess. And then we try to coach our employers into putting forward settlements or to do terminations on the basis of reasonable ranges, so that when someone goes to a reputable law firm for legal advice on their package, that the legal advice they get is, this is in the range of fair. There's no point in litigating. Litigating is a sum zero gain for the employer. It's all bad news. You're still going to have to pay at least the reasonable range, but on top of that, you're going to end up paying legal fees along the way. And perhaps if you've been really hardball at it, you'll be paying their legal fees as well.
Okay, thank you. Now, you mentioned negotiation. Don, we had a number of questions from the audience on mediation, arbitration. Can you sort of give a summary of what the process entails and how people would go about engaging that particular solution?
Okay, so in the case of both mediation and arbitration, what you're doing is coming up with an alternative solution. They're both under the realm of alternative dispute resolution to try to resolve the issue. In mediation, an experienced, able person who is skilled at bringing people together seeks to facilitate an agreement between them. In arbitration, such a person, mediation perhaps having failed, then does what a court would do, that is, adjudicate and decide the dispute. In both cases, you need a specific agreement. Sometimes in business contracts, you will see arbitration clauses already in there. Frequently, what has to be done is to create a new agreement for either mediation or arbitration or both. And if this is the appropriate point, there is such a thing as Med-Arb, where a person selected by the parties first attempts to bring about a mediated solution, and if that fails, puts his or her arbitrator's hat on and decides the matter in their capacity as arbitrator.
What are the advantages and disadvantages of using the same person in Med-Arb?
Well, some purists say, you shouldn't mix the two together. If, however, you have selected a person to be the mediator arbitrator in whom you have complete confidence, and most important, that person is prepared to wait and hear the evidence. So the mediation has failed, you move into the arbitration phase. That person does not have a preconceived idea, listens to the evidence, and then comes up with the arbitrated decision. If you have confidence in that person, it can work very well, and it is very expeditious.
Thank you. Pavle or Andrew, do either of you use this process, and what's your experience with it? Pavle?
Yeah, I've used it in complex matters. Somebody who is a top-notch mediator or arbitrator usually will do both, and will have the experience and the practical ability to sever, because they're very different skills. Retired judges and experienced practitioners will generally have both if they're offering either, and can separate the two. We've had extremely good experiences. I can think of one case where we had a very difficult case. Mediation failed. The arbitration turned into a 13-day trial, and but it would have been, we got it resolved in less than a year, instead of, the average is 7 in Ontario, and instead of 4 to 6 week trial, it was 13 days, 2.5 weeks. So even though we had to pay the arbitrator fees, the cost benefit analysis, it was a no-brainer. It was far, far cheaper.
Okay, Andrew?
Yeah, I use it. I think of all these things as tools in the toolbox. You have to assess the value that you can get from an arbitration or a med-arb, and what the cost you predict will be, and you weigh that against the cost and the time involved in a lawsuit. And very often, a skillful mediator can help you get over the hump. I use it a lot actually with clients whom I'm having difficulty sending the message to, because they need to hear it from someone outside. They don't need to see me as fighting against them. So a mediator can do that without sacrificing the sister-client relationship.
Okay. Pavle, you mentioned the average litigation taking 7 years. What's happening during COVID with the courts? Don, can you maybe comment on that, or Pavle?
Pavle first, and then I'll make an observation.
Thank you.
My vague gesture with my thumb was that time is going up. There was the sad reality is the courts were shut down for a period of time as well, and that creates a backlog anytime. The courts have also had to pivot to online functions, which they were quite behind in Ontario in terms of their ability to effectively manage litigation electronically. That is I think, go forward efficiency that is now baked into the mechanism. So over time, gradually, you will see that the time to resolutions shorten. But the reality is, I saw an initial sign of hope that, the bar responded by becoming more cooperative for a time to work through solutions during the shutdown. Unfortunately, I'm seeing now that the bar and the courts have pivoted back to online mechanisms, I'm seeing some of the old behaviors creep in again as well to more litigious behavior. That's unfortunate, but the efficiencies that the court has baked into its processes, touch wood, seem here to stay. So I'm hopeful for the future that the process will be more efficient. Judges are becoming more interventionist at procedural steps too. They'll hop you on a Zoom call and bounce the lawyers' heads together to avoid procedural motions, which is wonderful and does a great service to stopping logjams without delay and ruinous cost of motions. A good case is one that never has a procedural motion, and that's something that I hope will continue.
And I would add briefly, if I may, the courts have a terrific backlog. They already had a big backlog, but with COVID-19, they've got a bigger backlog. They are responding with Zoom attendances. They're conducting trials now by Zoom, which, had it not been for the pandemic, I think the profession would have resisted, but they don't anymore. But nevertheless, despite all of that, and certainly I hope that the courts can deal with this effectively. Nevertheless, arbitration and mediation are more expeditious and generally less expensive.
So there's a bit of a paradox then, because you're all litigators, and yet what you're saying is that the best solution is in fact to try to avoid by coming up with these creative solutions, or the mediation, arbitration, or med-arb. Is that right?
Yes.
Okay, thank you for that. I'm going to go to Andrew with another question from our audience. It's difficult. Many businesses are having people with little or no notice just call in and say, I'm not coming into work, and using their COVID as the reason. Sometimes it's legitimate, sometimes it's not. But as you can imagine, if you're already an unbelievably stressed out business trying to make a dollar here, it kind of leaves you up the creek with no paddle. What, if any, are the rights, or what steps can the employer take when someone just calls in?
Yeah, this is a question actually we've received a lot, and I would put it this way. I don't want somebody coming into my, and I've recently had this where someone in my office has called and said, I've got a fever today. I don't think it's COVID. What do you think I should do? And our response was immediate. Don't come in the office. We can do it. Now, some businesses can't, you know, where you've got manual labor involved, construction industry, things have to get built, people have to be there. But if your construction crew gets taken down with a spread of the pandemic, then you're really up the creek. And so, as difficult as it is, I would say to you, you just gotta err on the side of caution. The law requires it too, but there's another better reason for it. If you demonstrate to your people that the reason, and I've seen this is not just me spouting off pie in the sky, but the employers who demonstrate that they care about their employees will find that they will have fewer employees who take advantage of that situation. It gets back to, and this is non-pandemic related, our philosophy for our management consulting has always been hire slow and fire fast. Hire your people slowly. Make sure you get the right people. Make sure that it's not just that they can do the job, but that they can do the job and show some loyalty to you, some cooperation with other employees. And if they can't, fire them fast when it's not expensive to do that. And over and over again, I see employers with 20-year employees, and they will tell me this employee has been bad for 10 years. Why didn't we get rid of them at the 10-year mark? It's frustrating. And I know how hard it is. It's very, very difficult. I've had to do it myself. I know it's really unpleasant, but maybe that's why you need me, because I'm going to kick your ass and make you do the right thing as much as I possibly can.
Okay, thank you. Pavle, can you tell us what Bill 218 is and what the impact will be?
Yeah, it's proposed litigation, proposed legislation to stem the tide of COVID litigation. So essentially, I think there was a worry of our already beleaguered court system being cluttered with cases of, I went to a store last Friday and I got COVID, so I'm suing that store for my lost work and sickness and my dog and the vet bills for my dog. And the essential prospect of this is that it would not only beleaguer courts, but also businesses that are already struggling to have to deal with spurious litigation. And so it's just a hard tool to say, no, we're not, as a society, we're saying we don't want this kind of stuff to make a bad situation worse. And the hope is that the carve-outs in the legislation are narrow enough that people aren't going to use COVID as an excuse to sue each other and make the pandemic economic ramifications even worse than they already are.
Okay, thank you. Andrew, a very similar question with respect to Bill 128. What is it? What will the ramifications be?
Well, I hope that I've got the right Bill 128, because there are several. But it's just an act, if it's the correct Bill 128, because each parliamentary session has a new Bill 128. We've assumed that the question relates to employment law, and therefore that it's the bill that amends the Workplace Safety and Insurance Act. And what it does essentially is it does not reduce a pension, or does not allow a pension to reduce someone's entitlement to workplace safety and insurance proceeds. I'm hoping that that's the act that was the subject of the question. Irene's gone now, so I'll take charge.
I'm coming back.
Oh, I'm going to take charge.
Sorry about that. The big chief was here. Okay, so back to Dawn now. Yeah. Dawn, there's a song by Kenny Rogers from The Gambler. You got to know how to hold them, know when to fold them, know when to walk away, know when to run. What advice can you offer to our audience on when cooler heads don't prevail and they're going to be engaged in the process and it's going to cost money? How can they manage the costs, including with their lawyer?
Okay, so we're assuming that initial discussions have failed, attempts to set up a mediation or an arbitration have not succeeded, and there's no alternative if you're trying to protect yourself but to go to court. So you're going to have to, the business person is going to have to get as good an estimate as he or she possibly can from the lawyer as to what it's going to cost, and is going to have to come up with a plan in conjunction with the lawyer as to how those costs are going to be paid out over time. So it's financial planning 101. Best not to go there unless there's no alternative. But I take it from your question, all the other alternatives have been exhausted. So you're going to have to hunker down, go through it, and you're going to have a financial plan to pay for it. And you're going to have to work that out with your lawyer, because the lawyer may have to wait a while to get some of the bills paid.
And Pavle, that must be a particularly difficult situation with your clients. What do you do, or what advice?
It depends on the nature of the dispute. I mean, if ultimately the client is looking to get into litigation and thinks they can weather the storm, something that we can do that we've seen help clients is the costs of litigation are pretty spiky. You know, there's stages in litigation, and you can get a big bill all at once and then radio silence for months. And when a business is financially stressed and managing cash flow, something that can really help is prepare a litigation budget at the very outset, but then spread out the cost to a monthly fee. And that way you build it into your cash flow. You know exactly what you're going to have to pay month to month. You stick to the budget. You revisit it periodically. If we're not using it and don't expect to use it, if the costs have changed, whatever, we can reduce. If it's going up, then we have a talk and either extend the payment period or whatever. But that's something that you can do to help. And it's very easy, if properly managed on both sides, to come up with that sort of accommodation. And similarly, you know, it's in addition to the financial planning, it's also having a litigation plan at the outset. That you don't, the worst thing that you can do is, you know, this joker's out of line, I'm going to sue him without a plan in place. You want to, if you're on the suing end or the receiving end, you start with a plan, not only on the financial side, but also what's your end game of this litigation and how do I get there? And a good counsel will help you do that.
Thank you. Andrew?
Yeah, I think again, we go back to what we were saying initially, that is, come see us early. We can help you create a cost-effective plan. It's a lot easier to terminate an employee if we plan it in advance. We can do it without litigation. You know, these things, if you need to terminate, we can do that termination in a cost-effective way. A little planning, I think that's a great idea. We'll give you the litigation plan as well. But just come in and see us early. Let's talk it through and figure out what works best for you. And if you've got an employee, we're terminating employees. We're terminating employees for cause as well during this time period. These things can still be done. They just can't be done in a knee-jerk fashion. So come and see us and we'll help you.
What I'm hearing, the theme across the board here is planning, 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 and engage with your lawyer early. It may end up being a lot more cost effective.
Correct.
Now, Tim, I don't know if you are still on the line, but do we have any questions from our audience?
Thanks, Irene. I'm here and we have nothing new at this time. So seems as though a lot of the questions were asked ahead of time, and you're doing a great job of responding.
They were very, very good questions. In fact, I'm going to say to the people in our audience, if you have any further questions at all, please don't hesitate to send them in. I know that Andrew and Pavle and Don, it would be their pleasure to respond to your questions. Our final question, when the three of you look at this awful situation that we're in, and someone did ask, what should we really be worried about? What's coming down the road? And what I've heard from you today is maybe the worst hasn't come yet, because there's just people have held on, and things are about to get a lot worse. So can you comment on what people should be worried about and what else they might do? Final advice for our audience. Anyone can start here.
I'll go first here. I think that maybe the problem that the really disappointing, the really debilitating problem that we're going to see is when things get better and we've decimated our workforce in an effort to try and make ourselves respond to this small little blip in our history. It may feel very, very painful now, but if you don't plan, and I don't mean just planning with a lawyer, but planning with an accountant, plan with all of the experts that can help you to decide what your future is going to be, because there'd be nothing that would be more unfortunate than to have a revival in the economy, have a revival in your business, but not be able to respond quickly to that switch. And so
excellent point.
My advice to people is you have to plan these things like everything else in the world, like everything you've done in your business to be successful. You have to have a plan that looks beyond today and looks into the future. There is a future here, and I would suggest that people look at this from a positive perspective and not just from the negative perspective. We can't ignore the negatives, but look to the positive.
Thank you so much for that. Pavle or Don?
Yeah, I would say this winter is going to be very difficult. The growth in the number of COVID cases is disheartening. It was predicted by scientists that the second wave would be worse than the first, and that has occurred. So certainly there are a number of people in difficulty. However, we have to take the long view, and we will come out of this. And there are now several good vaccine candidates coming along. When the economy turns, it will turn very quickly in a positive direction. And the reason for that is people who actually have some savings, they're not spending them now, but they will be then. They will need new things around their homes. They will need all the sorts of things that
Thank you.
Consumers spend on. Take the long view, try to figure out with people who can assist you in the planning how to survive, and keep your eye on next summer. I think it's going to be a lot better by then.
Thank you, Don. Pavle?
Yeah, the one piece of advice I would give, I echo everything that Andrew and Don have said. The one piece that's very, more narrow and tailored to my practice is this. I mean, what I've seen the past 8 months is an alarming number of people just walking away from their business, not doing formal filings, not going through the pain of restructuring, but just abandoning. That's a terrible strategy to employ. It opens you up to all sorts of personal liability, potentially, depending on the circumstances, how your business is structured, and follow-on litigation that'll come down the line in good times when people have the resources to throw at it. The pain of going insolvent doesn't mean bankrupt. Just because things seem dark doesn't mean you can't find a way out of it if you take the short-term pain of struggling through it, weathering the storm, winding things down if you have to in an organized manner, so that you can come out of it with a new business once this is all over and the economy shuffles, and you can be nimble to take advantage of all the opportunity that's around the corner, because it is around the corner. And the way to take advantage of it is to position yourself to be able to do so, and to do so quickly.
Good points. Thank you all so much. Tim, do you have any concluding comments? You know this audience far better than we do. Not to put you on the spot, but
always happy to be put on the spot, particularly by you, Irene. No problem whatsoever. And you know, I've been sitting here just absorbing as much of this as I can. There is certainly has been some technical jargon used, and I think it's been well explained. There have been significant number of practical tips and tricks that have been shared with us. And what's coming through loud and clear for me, and I think it's been reiterated a number of times by each of our panelists, is that early communication and good communication and continuing communication is important. Planning is important, and that's something that we preach from the Small Business Enterprise Center to all businesses.
I know it is.
Business planning, to have a plan. It doesn't have to be a 70-page document, but to create something that helps you generate that roadmap to make better and more informed decisions and choices is important. And not that this is an event to create a sales pitch for any one of our panelists here, but engaging early seems to be a really good and practical piece of advice, because ultimately the session title here is Avoiding Costly Litigation. And I think everybody's reinforced the message that to avoid incurring exorbitant costs, early engagement is your best path forward. So we speak in terms of business development around building a team of support around you, and the lawyers, the legal team is of certain importance at this time.
Tim, have you, under Ask the Expert, conducted a session on business planning during COVID?
We have, yeah. We've done one on creating business model canvases, which is, it's not new, but it's certainly an area of focus for us, which is really a one-page business plan, and it's a really fun session to watch and can be found on our simco.ca Ask an Expert website.
Well, not to do a sales pitch, but if you consider doing one in the future, I would think there would be merit in doing a cross-disciplinary business planning with perhaps CAs, accountants, and I'm sure these gentlemen would avail themselves again as well. But thank you again for the wonderful opportunity to speak to your audience. We always welcome this. I'm going to say that all of us here are small business owners ourselves, and we're going through the very same things that everyone in the audience is going through. And beyond all of the rates and fees, we want to help out. So pick up the phone and call us.
Thank you, Irene, for moderating the session today. To Pavle, Don, and Andrew, thank you for your words of wisdom. We do appreciate it. And I'm pleased to mention that, you know, this session, along with all the others, will be held in a library of resources that's available to our business community. So those that couldn't make it today will be able to be directed to that. So once again, thank you to each of you for your attendance and participation in the panel.
Our pleasure.
Thank you to our audience.
Yes.
Thank you.